Everyone, I'm pleased to join Mickey Amery, Minister of Justice and Attorney General, to announce proposed legislation that, if passed, would further strengthen and protect freedom of expression of Alberta's regulated professionals. Today, we are introducing Bill 13, the Regulated Professions Neutrality Act. This is common sense legislation that would recognize that everyone should have the right to express their personal views freely. No professional should fear losing their license, their reputation, or their livelihood because of a personal opinion, a social media post, an interview, or open dialogue outside of working hours. Specifically, the bill aims to protect expressive off-duty conduct. It draws a clear distinction that regulators are responsible for competence and ethics, not policing beliefs or personal expression that has no bearing on a person's ability to do their professional practice. These changes come after one of the most notable cases of professional regulators punishing an individual for comments made outside of a professional setting, and that is Dr. Jordan Peterson. Dr. Peterson was sanctioned and ordered to undertake a so-called re-education program in order to maintain his credentials for statements he had made outside of a clinical psychology setting. Similar notable cases have involved nurses, doctors, and teachers that have been punished, sanctioned, or have had their licenses threatened for comments that they have made on social media, at protests, or even at meetings of local city councils. We looked at these cases and asked an important question. Are regulators still focused on public safety and professional competence, or are some of them overstepping to enforce ideological conformity and to silence public discourse? Professional regulatory bodies play an important role in safeguarding Albertans, whether it's through enforcing standards or the implementation of policies, and we appreciate their commitment to protecting the public interest. But the role of regulators and the role that they play and should stay in is in the workplace. When regulators begin disciplining people for simply speaking their mind on their own time, that's overreach. And at its worst, it becomes an outright threat to free expression. And I can tell you that when we worked on Bill 9, we spoke to many professionals who were afraid to put their names in the public realm, not only due to the threat of public cancellation, but mainly due to fear of losing their professional status or their livelihood. It was a wake-up call that led many of us to realize that the conversations we aren't having can be the ones that are the most critical. Limiting or prohibiting expression narrows public discourse and cuts off opportunities for open discussion. Both are foundations of democracy and integral to every citizen's ability and right to fully participate in society. No one cherishes their freedoms like Albertans do. This is a sentiment that we hear often and something that our government takes seriously. Last year, our government reviewed more than 100 regulated professions to assess whether regulatory bodies were upholding the rights and freedoms of their members. At the time, we indicated if legislative action was needed, that we would take it. And today, we are living up to that promise with what we're calling our Peterson Law. Overall, our aim is to uphold professionals' rights and freedoms while continuing to protect the public interest so that both public confidence and professional integrity are maintained. We want to ensure that professional regulatory bodies keep their focus on areas within their scope, on members' actions that affect their professional competence and ethics, because everyone has the right to express themselves and to share their views and to have their voice heard in our society. Now I'd like to invite Minister Mickey Amery to speak more about Bill 13.
Well, thank you very much, Premier. Good morning. Today I'm looking forward to tabling Bill 13, the Regulated Professions Neutrality Act, in the legislature. As the Premier mentioned, a year ago, our government announced that we would be launching a review of Alberta's regulated professions to ensure that freedom of speech and expression of their members are protected. We signaled a year ago that we would introduce legislation to do just that, ensure that regulated professionals may freely express themselves while still being entitled to fair treatment by their professional regulators. Albertans value free speech. We value the freedom we have to express our beliefs without fear of censorship, and especially without fear that anyone will police our personal opinions. The Premier touched upon a few examples of high-profile cases where nurses, doctors, teachers, lawyers, and many other professionals have been disciplined or even had their license taken away from them for simply expressing their personal beliefs. Instead of regulating competence, conduct, and public safety, some professional bodies have begun regulating beliefs, personal opinions, and off-duty expression. That's why this legislation is important. We do not want to see this trend continue here in Alberta, and we believe that this important piece of legislation draws a clear line. First, it prevents regulators from disciplining their members for lawful off-duty expression. This legislation outlines a clearly defined list of exceptions, serious misconduct, such as threats of violence, breaches of professional boundaries, or criminal convictions. Second, this bill establishes neutrality principles that require regulators to treat everyone fairly, regardless of the personal beliefs that one might have. The intention is to ensure that regulators operate fairly and without bias. Third, the bill limits mandatory training. Any kind of training or education can only be required when it relates specifically to professional competence or ethics. Regulators will not be permitted to mandate training that attempts to prescribe particular political or social viewpoints. Any education or training that addresses political, historical, social, or cultural issues can only be required if it's directly related to professional competence or ethics and necessary for that purpose. And it must not attempt to prescribe the range of acceptable opinions on those issues or on matters of personal conscience. Finally, this bill strengthens avenues for appeal and review, ensuring that professionals can have their rights upheld in court if necessary. In short, this bill restores balance. It ensures that regulatory bodies remain focused on what really matters most: competence, ethics, and serving the public, while guaranteeing that professionals retain their fundamental freedoms as citizens. Albertans must have confidence in the professionals who serve them, and those professionals must have confidence that they can hold and express their beliefs without fear of being disciplined or leaving their profession. Bill 13 protects that balance, and it protects the freedoms that Albertans treasure. Thank you very much.
Thank you. We'll now head into the media Q&A portion. A reminder, this press conference and any QA related to the bill is under embargo until that legislation is tabled. We'll start off with questions here in the room before making our way to the phones and a show of hands for those in the room. We'll start with Janet, then we'll go to Catherine.
There are some regulated professionals right now who are not very happy with your government. What are you going to do when they use this expanded protection from professional consequences to criticize your government? Are we going to see a walk back of this?
Well, I don't think anybody's shy about criticizing our government. I think what we have heard, though, is that there are people who are concerned that they're going to get punished by their professional college if they support our government. And I'll give you two examples that I got yesterday. One from a doctor who wrote to the president of the AMA, which is his union, about his stance on our Bill 9 law. All of our disability and other benefits are through the AMA, so we risk losing all of that, but they just phone the CPSA and AHS, and the next thing they know, they lose hospital privileges or they need to take a $5,000 course. Almost all of us who have stood have endured this kind of treatment. I got a second one, very similar, doctor who's about ready to throw in the towel on medicine, apart from regularly suffering from workload issues. I believe CPSA is persecuting me for raising concerns with their ideology. I'm now undergoing mentoring that is costing me almost $10,000 in loss of revenue. These are the stories that we hear. I don't think that we have anyone feeling shy about criticizing us as a government. I think what we have a problem with is that doctors and other health professionals have a problem standing up and defending some of the decisions that we make. And that's what we want to restore, is a little bit of balance.
Is there not a gray area here, though, where, I guess we'll go back to the COVID era, where people may be using their freedom of expression to say, I think we should put more emphasis on trying these medical treatments for which there's no evidentiary backing or value. Is that freedom of expression, or is that wandering into practice? How can a regulator deal with that?
Well, let me deal with the current case. The fact that the Americans just took the same stance that we did on puberty blockers, as did New Zealand, as has Finland, as has Sweden, as has the United Kingdom, and virtually none of your media coverage or any medical professionals have expressed that view. That's what I'm concerned about, is that there are a lot of countries in the world that have taken a very similar stance that we have, that this kind of medication is not approved for use for this purpose, has unknown future consequences. There have been no clinical trials, And not only do we see no reporting on it, we also see no medical professionals willing to speak up about it. So I believe that that is important for a robust debate. And that's one of the reasons why I think that we need to be able to have a diversity of viewpoints in the medical field. I think there were many things that happened during COVID that turned out to be walked back after COVID. The efficacy of masks is an example. The incorrect information that vaccination would lead to no transmission, which turned out not to be true. So I think that there were a lot of doctors who were trying to raise the alarm about those kinds of issues, and now we accept them to be true, but it would have been helpful to know that at the time and have free discussion at the time. So I don't fear having a robust discussion where you've got a difference of medical opinion. What I do fear is that there's a narrative that sets in that prevents us from being able to look at science and as it evolves, because that's what science is that there are a thesis, a counter thesis, and then ultimately through investigation we get further and further knowledge. And I believe that by not having that kind of an environment, it actually makes us poorer as a society.
We'll go to Catherine.
Yeah, so on these limits on mandatory education and training for professional competence and ethics, there have been some regulatory bodies that do think it's important for their professional competence and ethics to have that historical context, that cultural context when upholding their profession. So why do you think the state should get to limit and have a say over what is important to this professionals, over the professionals themselves, determining what's important in education?
Well, look, I think we need to frame it a little bit more properly than that. The Act itself creates a distinction between what is relevant and what is not relevant to a professional's competence and ethics and training. And nothing in this Act would preclude a regulator from imposing training that is related to the professional competency and ethics. But what we're saying is that if it is to further a political, social, or cultural objective, and that is a debatable issue in general, then this Act will prevent that from happening. If there is a push or a drive from a regulator to impose upon its professionals some sort of political, cultural, or social ideology, and it has nothing that relates to the professional competence or ethics of that individual professional, then it will not be permitted to happen in this province.
I have an off-topic question, and this is for the Premier. It was raised in question period, but you don't have a lot of time to respond there. So on April 23rd, you were asked to clarify your stance on the Public Health Act as it related to the public health guarantee. And you said, one of the main principles is that no one pays out of pocket for a family doctor, and no one pays for hospital services. Now that's different than no one has to. So the NDP have said, hey, you didn't run on this, call an election on it. So why did you not run on this if you think this is an excellent solution?
We have said no one will ever have to pay for out of pocket to see their family doctor, or ever have to pay for the medical treatment that they need. However, there are circumstances where an individual may wish to pay, removing themselves from the queue. That not only allows for somebody else to take up that space, but it gets more surgeries done. This is the kind of approach that they have in New Brunswick. It's the kind of approach that they have in Quebec. There already is the ability right now for doctors to opt out of the healthcare system and be able to receive direct payment. We just allow this legislation is just going to allow them to toggle back and forth so that we don't lose them, quite frankly, from the public system. One of the stories I read suggested that in Quebec, there's over 800 doctors who have now chosen to go 100% in private practice. We're doing the opposite. We're saying we expect that anyone who does this is going to have to maintain the service levels that they have, and that they would have to look at doing this in their off hours. And we reserve the right from time to time to say, sorry, this particular profession or this particular area of surgical practice is off limits. We've already said that for cancer treatment and for emergency surgeries, but we know that that what we've been doing just simply hasn't been working, and we want to try something new.
And then we'll go to Skase and then Sam.
Premier, yesterday's Auditor General report into Dynalife said access to information was restricted by AHS and supported by the Department of Health. Legal and cabinet privilege was claimed without explanation. Lawyers conducted line-by-line reviews of over 10,000 documents. This is the second time an investigation has cited major issues with access to information. Can your government be trusted to be cooperative in future investigations and ones that are ongoing?
Well, I can't speak for the conduct of Alberta Health Services, and I know that he had some very harsh words about their retention of records, but I can tell you that the government did, in fact, cooperate fully with the Auditor General's investigation, and I think any suggestion to the contrary is incorrect. We, when Minister LaGrange first became Health Minister, she looked at this file and made an immediate decision that we had to take action on it. It clearly did not get implemented as had been anticipated. We were seeing loss of service, we were seeing long waits, and the company demonstrated that the savings that we thought we were going to get would not materialize. My recollection at the time is that initially they were talking about saving $100 million by going this direction. With some of the modifications to the modeling, it turned out to be $35 million. But when Adriana took a closer look at it, it was actually going to cost us $70 million more. And that wasn't the commitment. That wasn't the promise. And so I think that we came to a mutually beneficial agreement. They transferred the assets over. And to the credit of Alberta Precision Labs, we saw an immediate performance improvement. They went back to having more procedures or more tests that were available for booking online. And in fact, we just haven't heard the same kind of complaints. And that's what it was about, is can we create a system that will address these issues by doing the status quo, or do we have to change? And we made the decisive decision to change.
Off topic here too, your UCP AGM is coming up in about a week. Do you think there's room to discuss separation at your AGM?
Our members have an opportunity through open mic. I have a session with our party president. I've got a session with my caucus. I've got an accountability session where we talk about which policies they passed from previous years that we've implemented, which ones we didn't, and why not. And so I look forward to those opportunities. I'm not sure what will come up at the mics, but you guys will all be there, so I'm sure you'll hear just as I do.
Awesome. And we'll go to Sam, and then we're going to take a couple questions from the phone.
Premier, the province of British Columbia has signaled that it will support increasing capacity for the Trans Mountain pipeline. So if that happens, and there's not a new pipeline, is that enough for your government to sign on and commit to an MOU and satisfy your energy needs?
No. I think that what we're seeing is that there's a change in the public dialogue about the need for oil and natural gas. And I think encouragingly, we've seen a number of natural gas projects go ahead and be on the major project list. We're fully supportive of that. We're hearing from a number of different pipeline companies. Enbridge wants to expand their capacity. Trans Mountain wants to expand their capacity. South Bow has a project that would go to using some of the old Keystone assets to increase capacity. We're doing the technicals on a new pipeline to the northwest BC coast. We have a potential to also do something similar to Churchill in the Port of Prince Rupert to Churchill economic corridor. We've got proposals coming to us about how we might be able to export to Thunder Bay and get them out through the channel system there, through the St. Lawrence Seaway, as well as oil by rail going all the way to Sydney, Nova Scotia. So I'm very encouraged by all of these conversations. So my view is that the world is going to need more oil in particular. OPEC has now said it's probably 125 million barrels a day by 2050. And we need to be a growing share of that growing market, especially since we are going to have the lowest carbon intensity barrels. So I would say Premier Eby and I agree on a lot of things. And one of them is that we agreed on dredging the second Narrows to increase capacity. And we agree on expanding Trans Mountain Pipeline as well. But as you can see, I would like to see expansions in all directions.
What else would it take then for you to get to that MOU with Ottawa, and how close are you at this point?
Well, we're working on it. Still very hopeful. I was hopeful before the Grey Cup, which was one of the deadlines he'd set for new major projects. We know that we've got a little bit more work to do on the technical side to be able to submit our pipeline proposal for consideration to the Major Projects Office. We've targeted the spring on that. And if we do get to an agreement with the federal government, we'll certainly let you know. And but I remain very hopeful as our negotiations continue.
Awesome. Thank you. We're going to head to the phones now. Operator, could you put through our first caller, please?
Tim Brooke from CTV, your line is open.
Hi, this question is for the Premier or the Minister, whoever can maybe shed a little bit more light on question that was asked further. Minister, you said, it's debatable, essentially, how this legislation could be used. I'm just trying to get a sense of the scope here. Like, who will decide when it comes to training purposes? Who will decide what's relevant and what's not? I'm thinking, let's say, an example of the Law Society of Alberta putting members through Indigenous training, Indigenous law training. Like, who decides if that's relevant to the job and how far that training can be taken?
Well, thank you for the question. Alberta's government will always respect the role that professional regulatory bodies play in overseeing their members to ensure that professional competence and ethical conduct is upheld, and that will remain within the guideline or the handle of the regulators. I think that the regulators will have the RPNA to look at as an overarching umbrella piece of legislation, and that will guide the principles, but ultimately the decision-making process will lie within the regulators themselves. That being said, if the type of training that is imposed upon a professional exceeds what the Act allows for, then we'll certainly hear about it, and I suspect that the professionals will raise that issue with the regulators and perhaps with the court.
I might add, like, there would be some, and Mickey might be able to speak to it better since he is a lawyer, but there'd be some areas of law where that would be relevant, particularly natural resource law or environmental law, but personal injury law and real estate law, maybe not so much. So I think it has to be, you have to look at the particular type of practice that a professional is going to do and then gauge it based on that. But blanket training on ideologies is, and then enforcing speech codes, that's just not in the realm of what we expect our professions to do.
Great, thank you. My follow-up is for the Premier. Premier, what role, if any, do you think DEI has to play in society today?
Well, I think that the discussion about merit-based promotion is one that is really important. And if we have candidates who are able to meet all of the qualifications of a particular field or profession or job, we want to make sure that there isn't any discrimination against them. I think that's a completely legitimate thing for us to be doing. But I think that, let's be frank, DEI is a very highly charged ideological doctrine that teaches a particular perspective about colonialism and white settlement. And you have to ask the question, what are we trying to get to with that? Are we trying to get to a point where we have fairness in hiring and a diversity of people who are hired into positions, or are we trying to socially engineer some kind of narrative? So I think that it's pretty clear that there's a difference between those two things, and we certainly support merit-based hiring and making sure that we're removing any barriers.
Thanks, Tim. We have time for one or two more questions. Operator, could you put through our next caller, please?
Charles Delisle from Radio Canada, your line is open.
Hello, yes. My question is on the Regulated Professions Neutrality Act, and just wondering, like, why not make a difference between, like, a professional that has, like, a controversial opinion in their, like, field of work and someone who's putting out a controversial opinion on something that's, like, disconnected from their line of work, for example?
Well, I guess who's the one to decide? I mean, when I look at what we are asking the professional colleges to do, by and large, we want to make sure that their clients are receiving good service, that they're not being defrauded, that that if they're a government paid official, that they're not defrauding the government, that they're not engaging in unethical practice that is going to harm their patients or clients. That's foundationally what we want our professions to do. We don't look at them as being on the front line of creating some kind of social narrative that requires conformity. And so I'm hoping that the professional colleges understand that they've gone too far. And it could well be that through various challenges, they'll find the right measure. But when I continue, I'll know that we've succeeded when I no longer receive texts like the ones that I read out today from various health professionals or other professionals feeling like they have been targeted because they carry a viewpoint that does not conform with what their professional college wants them to say. That's not what these professional colleges are for. Did you want to comment?
Yeah, just a little bit. When we drafted this bill, the intention was to create a distinction between what regulators should be doing and what we think that they're doing. And the reality is that they've moved away from regulating professional competence and ethics into other realms as well. A number of examples that we've talked about briefly are important to highlight here. We've got nurses in BC and Ontario facing discipline for stances that they've taken and opinions that they've expressed online. We know that doctors here in Alberta, and there are public cases of that as well as the private ones that the Premier alluded to today, where they're not prepared to come forward and express their opinions either. Now, the Regulated Professional Neutrality Act seeks to create the parameters really for what regulators can do when it comes to expressing opinions, and that is to do so without fearing one's reputation and livelihood. But the most important thing here is this. Even if these regulators are moving forward in ways that we don't think that they should, and even if these professionals have done nothing wrong, the process is incredibly difficult and challenging for professionals. The first step is going through an initial regulatory hearing or a process, and that can take a tremendous amount of time and money. The second is often an appeal mechanism within the regulator's process developed by the regulators, and that is, again, a difficult, challenging, and expensive process. The next process following that is to seek the court's intervention by way of judicial review, for example. And we all know how expensive and time and lengthy that is. And then finally, an appeal if that's necessary. And the reality is that we're subjecting professionals who express their opinions on things that are important social issues and putting them through this process time and again in countless different situations. That's simply inappropriate. We want our regulators to come back to what they were intended to do. Regulate professional ethics, regulate competence, make sure, for example, that our doctors are good doctors, make sure that our lawyers are good lawyers, and leaving it at that. And that's what the intention of this act is.
Thank you. No follow-up. Thanks.
Thank you. And we have time for one more question. We'll take that from the phones. Operator, could you put through our next caller, please?
Jamie Sirconuk from National Post. Your line is open.
Good morning. This is for the minister. Does the legislation prohibit the Law Society from mandating the task force?
The task force?
The PATH course, yeah. Jamie's referring to a course that was made mandatory for lawyers here in Alberta, and we heard a tremendous amount of opinions in relation to that. That was a course related to the history of First Nations in Alberta, and many lawyers have expressed their concern about whether or not it relates to what they do. The Premier mentioned earlier, a real estate lawyer doesn't necessarily have a whole lot of a need to go through a course on various issues relating to social or cultural context, and this is perhaps one of those that might fall into this. Jamie, I won't speculate on what might or might not be banned, but I will say that we'll address them as they come.
Right. So I suppose my follow-up is just the Law Society is clearly going to say this is relevant to professional competency because that was their initial argument for putting this course forward, even though the course has various political elements to it. So, I mean, if the standard is just if the regulator says that this is relevant to our profession, it would look like the PATH course would be fine under this scheme. So, just looking for a bit more of a follow-up there.
Yeah, I think you're asking me if the PATH course would have been would have gone forward with the RPNA in place. It's difficult for me to speculate on what might have happened, but my inkling is that it probably would not have been because of the nature of the course and the nature of whether or not it's relevant to the work that lawyers do necessarily. And so I would probably say to you that this is an assessment of a case-by-case basis, like every other type of interaction that a regulator has with their professionals. But to speculate on what may or may not be permitted under this act would be nearly impossible right now. We'll assess it as they come. They will arise certainly going forward. We were certain to see cases where a challenge is made, and then we'll assess it at that time. But it's difficult to speculate on something that hasn't happened yet.
Thank you. And that's all the time we have for questions today. Thank you, everyone, for joining us.
Thanks, everyone.